So I believe we have all the participants and we are all good. So let's start.
So
good morning, everyone.
Maybe that we can wait for some time.
Yeah, we can wait for another 5 minutes or 2
3
3
minutes. 2
yeah,
minutes.
2 minutes. Yeah.
I think we start now.
So let's go ahead. Good morning, everyone, and good morning to today's webinar on insolvency resolution and bankruptcy of individuals who are guarantors to any corporate loan. And this has been effective since December 2019, and we see a lot of activity in this area lately as more and more banks and creditors are now looking at this approach to make sure that the assets available with the guarantors to any corporate loan are also available for resolution of any bad loans. So I believe we don't need any further waiting time. We have a good number of participants. So I will request Anil sir to start his deliberation. We will keep a format in a way that we will keep taking up questions every few minutes. This is a 1-hour session today, which is going to be continued with a part 2 next Sunday. And that's how we will carry this out. So the Q&A is what I will see for any questions that you spot on. I will skip the chat box. Please put in your questions on the Q&A.
Thank you, Ankit. Good morning to all the participants. I'm Anil Goel, and this is our passion at AAA to share our knowledge and experience with all professional colleagues, bankers, anyone who is interested in the subject. This is without any promotion, without any politics. This is clearly a knowledge session, and the format that we have, because this is an individual insolvency is going to be a very, very important subject in the coming years. Presently, it is only and only applicable to all those individuals who have given any guarantee to a loan given to any company or any LLP. So it is not applicable to any other individual. However, the law is the same. The individual insolvency law, individual bankruptcy law is the same without any change. Whenever it will be notified, whatever we are learning today, that exactly would be used for all individuals or even partnership firms, proprietorship firms, with a slight difference. And that we will discuss whenever this will be notified. However, why I'm saying so, because this is very important subject. Individual insolvency has to come. It has to be implemented. It is an international norm, and this is the requirement of ease of doing business in any country. So therefore, the government definitely would do that. It is only the capacity of debt recovery tribunals present challenge, and also this is a social economic issue. India being a very large country and different economic segments that we have in India, maybe that at some point of time it is uh, politically also becomes a little bit of challenge. However, the law has been made, the law has been passed by the parliament. Only specific sections has to be notified whenever government decides. The regulations for personal guarantors have been made. The rules for the personal guarantors have been made. So whenever this individual insolvency for all individuals in India would be applicable, some minor changes would be made in the rules or in the regulations. Otherwise, everything is the same. So this what we are doing is that the first process is, the first part is insolvency resolution process of individuals who have given any guarantee to a loan to a company or to any LLP, which we call corporate debtor. We, since the subject is large, it is applicable to all individuals, whatever we are learning. These 2 sessions will be taken for the insolvency resolution process. Thereafter, we will come out with the bankruptcy, which is rather more important than the individual resolution process. The bankruptcy is an ultimate for providing a discharge to any individual. So the 2 sessions would be for bankruptcy, and then we would focus on why individuals should use this law for their economic liberation. How can they get free from all past economic liabilities? So that would be our last, and we would focus on that. We would try to propagate that it is useful for all individuals who have some financial stress and have given some loan to some guarantee to the loans. So this is a clause by clause session. So I would go through the slides that I have prepared for all the relevant portions. So we will start with the notification of the individual insolvency law. It was notified on 15th of November 2019, and it was effective from 1st December 2019. So the notification was very simple. Only one clause of section 2 of IBC was notified, that is clause E, personal guarantors to corporate debtor. However, the clause F and clause G is still not notified. Like partnership firms and proprietorship firms, not notified. Individuals other than persons referred to in clause E means personal guarantors. Leaving personal guarantors, the other individuals are not yet notified. The sections 94 to 187 is notified. And see, like this, there are other sections which are notified, which are relevant to individual insolvency, for even making rules, for making regulations. All these powers were given to IBBI and Ministry of Corporate Affairs by notifying these sections. However, this section 249, which was already in the IBC, that was also notified on the same day. And this particular section 249 is very important. See, when this particular law was conceived in June 2016, when it was notified with effect from 1st December 2016, at that time, we never realized that this particular law has that kind of vision. And that vision was that when we will notify the individual insolvency provisions, then they will also notify the section 249, which actually means that that also would be amendment to the Recovery of Debt Due to Banks and Financial Institutions Act 1993. So the first amendment was that this particular act, the name of the act, the Recovery of Debts Due to Banks and Financial Institutions Act 1993, also gets changed. And now, with effect from 1st December 2019, the name of the act is the Recovery of Debts and Bankruptcy Act 1993. And this name was changed by IBC, which was made in somewhere in June 2016. That was the vision at that time, that this whenever the individual law would be notified, the debt recovery tribunals will have an additional jurisdiction, and this particular, the Recovery of Debts Due to Banks and Financial Institution Act would also have a different perspective, and the bankruptcy law also would be having the bankruptcy law would also be under the same jurisdiction and under the same procedures as we can see under RDB Act now, because now we call it in short RDB Act, the Recovery of Debts and Bankruptcy Act. The government also in section 249, it is also said that the government will set up the requisite debt recovery tribunals and also the debt recovery appellate tribunals. And it is also mentioned in the section 249 that the tribunal shall have circuit sittings in all district headquarters for debt recovery tribunals. So this is the kind of preparation which was done in June 2016 when this law was being made. That was the vision of the government. It is only the notification is delayed, but the intent is definitely very much. So whatever we are learning today, it is not only applicable to personal guarantors, it would be applicable to all individuals of this country whenever it is notified. So therefore, for every chartered accountant, for every company secretary, for even a whole household, every person who has a commercial life, knowledge of this law is very important. So presently, it is only applicable to personal guarantors, and the definition of personal guarantors. Definition of personal guarantor is a debtor who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So there are three components. One, that the individual must be a personal guarantor to a loan given to corporate debtor. Then the creditor has invoked the personal guarantee and the individual has not been able to pay that in full. So these are the three factors before any insolvency of an individual can be started under these provisions. Now let us see the jurisdiction, which is a very, very important part for the discussion, because I have actually been getting the questions also from the interested people. They would like to understand the jurisdiction. First of all, I would actually see that the jurisdiction is actually mentioned. Jurisdiction is mentioned in section 179. When I see the section 179 of IBC, you actually can see this in case you are able to read. The basic jurisdiction is under section 179, and it says, subject to the provisions of section 60, the adjudicating authority in relation to insolvency matter of individuals and firms shall be debt recovery tribunal. So this is only an exception, section 60. Otherwise, the jurisdiction is with debt recovery tribunal. So going back to the slides, there was an amendment again from 1st December 2019 in the DRB Act. Now we call it Debt Recovery and Bankruptcy Act. There was an amendment in that also. Now that amendment, coupled with the section 179, says that the jurisdiction of individual bankruptcy would be with DRT. However, subject to section 60. Now, when we go ahead and see what exactly section 60 says, section 60 talks about the, let us see section 60 subsection 2. Now, without prejudice to section 1 and notwithstanding anything to the contrary contained in the code, where the corporate insolvency resolution process or liquidation process of a corporate debtor is pending before NCLT. Now, what is pending? CIRP or liquidation is pending with NCLT, or liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, shall be filed before the National Company Law Tribunal. So in case the CIRP or liquidation of the corporate debtor is pending with NCLT, then the jurisdiction for corporate guarantors and for personal guarantors would be filed before NCLT and in the same bench where the corporate debtor is already there. Now, subsection 3 further says that an insolvency resolution process or liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, pending in any court or tribunal, shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or liquidation proceedings of such corporate debtor. So this actually means that in case today the individual insolvency is filed in DRT because the guarantee has been given, guarantee has been invoked, and the amount has remained unpaid, and the bank decides that we are not going ahead with the CIRP, or the CIRP applications are pending, but it is not admitted. So the bank can file an application to DRT, but whenever the CIRP application would be admitted by NCLT, then the application which is already admitted before DRT would be transferred to NCLT. So this jurisdiction question is actually very important. So see, the process says that in case CIRP is finished, the resolution plan has been approved, and there is nothing pending before NCLT, then the jurisdiction goes to DRT. In case the liquidation process is started and the company has been dissolved, then the individual insolvency, that means that the jurisdiction is with the DRT. So when CIRP or liquidation is pending before NCLT, then the jurisdiction is before NCLT. In all other cases, the jurisdiction is with DRT as per section 179 of the code. As per section 179 of the code, and in that case, the DRT will have a territorial jurisdiction over the place where the individual debtor actually and voluntarily resides, or carries on business, or personally work for gain. So this is a kind of jurisdiction. Ankit, I think you may have some questions on jurisdiction, I believe, because I was getting some questions from on jurisdiction part of it.
Not yet, but then like my own question is that say a individual has say multiple identity cards. One says election card says he's a resident of Delhi. Another card says he's a resident of UP. Aadhaar says he's a resident of Haryana. So in that case, will that person be able to create an issue with respect to the jurisdiction of the case? The second question that I have here is that in case the DRT case starts first and the company in which that person is playing a role goes into NCLT later, is there any provision for transfer of the case from DRT to NCLT in that case?
So the last question first. We've just read section 60, subsection 3, which says that any case will get transferred. Any case will get transferred to NCLT in case the corporate debtor is admitted to CIRP or liquidation. In case that case is already going before DRT. The primary jurisdiction under section 179 of the code is with the DRT. And in case the CIRP or liquidation of the corporate debtor is pending, then it is with the same bench. Second question is, like, as far as the Aadhaar is concerned or the election voter ID card is concerned, I think it is unlawful to have two election ID cards at different addresses. It is also unlawful to have two Aadhaar cards at different addresses.
No, I meant that somebody has a different address on their Aadhaar and somebody has a different address on their driving license, a different address on their election card. That might be possible. There might be a pendency with respect to changing the address. But the idea is that there might be a jurisdictional issue based on where the person ordinarily resides. How is that established? So there, I guess.
I think where the individual debtor actually and voluntarily resides, there can be multiple evidences for residing at a place. In case somebody say that I have recently shifted to Mumbai, and then he would have definitely ownership of a property or tenancy of a property where he is living, or it is not a question of temporary, because that should be a kind of a little permanent address, or in case he's carrying on business at a place, or he's doing a professional work but personally working, or in an employee somewhere. In all these three situations, there are word or. So I don't think it can be misused. So the DRT is a DRT. If a person actually, wherever he would be comfortable based on his residential address, or based on his business, or based on his job, that would be the jurisdictional territorial jurisdiction for the personal insolvency.
Then another question is coming from Mr. Shivam. He's asking that in case say a section 7 or 9 application is pending with the NCLT, in that case the jurisdiction will be NCLT or DRT. So based on my understanding from whatever you have deliberated so far, it should be DRT.
Now, the filing of application does not mean it is a CIRP proceeding or a liquidation proceeding. Filing of application, like anyone can file an application, but application has no meaning. Like application can be rejected, can be accepted, and there can be multiple applications. But the jurisdiction would change when the CIRP is admitted, or because the CIRP or liquidation is pending. As I said, application has got no meaning. There can be multiple applications against a company, but that doesn't mean that the company is under insolvency. Company is not under CIRP. Filing an application that this person has defaulted and the insolvency should be started, that's a separate issue. So very clear, the CIRP proceedings doesn't mean application for CIRP. CIRP proceedings, as mentioned in section 60 subsection 2, does not mean application for CIRP. But the application can be rejected very clearly.
So this can lead to some complications, in my opinion. Say a person, say a company there has been an application under 7 or 9 to take a company under CIRP. That application is pending before NCLT. The bank says also interested in taking the individual who is a guarantor to insolvency, and they file an application with the DRT. So one point is that say the NCLT application gets admitted, then immediately the application needs to be resubmitted with the NCLT. So
no, it is not resubmitted, it is transferred.
So the application
the word very clearly written is that the section 60 subsection 3 says shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or liquidation proceeding of the corporate debtor.
What I mean is the application before DRT is pending. It has not been commenced. The insolvency for the individual has not commenced. In that case, a new application will be required with the NCLT.
That case it can be transferred, because see the formats for filing applications, format for filing applications to DRT and to NCLT is same. The process is same. In fact, the NCLT will use powers of DRT. As you see, the section 60 subsection 4, you can see the national companies or tribunals shall be vested with all the powers of DRT as contemplated under part 3 of this code for the purpose of subsection 2. So the basic powers of DRT and NCLT would be same. The process is same. The format is same, and it is only a case of transfer of one particular petition from one court to the other court. And somebody will apply. Now this NCLT has admitted the application, so there is no jurisdiction with DRT. So the DRT will transfer to the same bench.
So I'll read out a few questions on this issue, because I think this issue should be resolved before we go forward. So one, Uttam Agarwal ji is saying whether case pending will mean after admission of CIRP or merely filing of application. So on some light on PNB Housing Finance Limited versus Goldie Gupta, NCLT New Delhi, as it says otherwise. So that's one comment from one of our participants. Then one says OA is for even for the assets which are not even mortgaged or PG not given. Okay, so I think let's move forward. I think this is fairly clear that the transfer is applicable, and the jurisdiction will be based on the address or whether the pendency before the CIRP or the liquidation cases.
So, so let us again reiterate what I say. One, that the as I understand, and I also feel that there are some gap in understanding of different professionals. I have also come across a an order from NCLT Chandigarh, where the application for individual on the very first hearing, the RP is appointed. And now the RP has to give a report under section 99 of the code. And then the NCLT Chandigarh will admit the case as a resolution process for individual personal guarantor. Now, it is the duty of the RP to point out that this particular jurisdiction may be incorrect, or the NCLT will adjudicate this matter, whether the proceedings under IBC means application also or not. My understanding, and after discussing with my various colleagues, we have safely concluded that simply an application to NCLT for initiating CIRP cannot be considered as proceedings of CIRP. The application is not CIRP. Application is not liquidation. So therefore, even if on the very first hearing of the application, the NCLT RP is appointed, and then the RP should point out this issue, whether this particular jurisdiction is correct or not, because see, the law has been made in such a manner that the time of the adjudicating authority is saved, and most of the responsibility has been shifted to RP regarding the eligibility of the personal guarantor, whether the completion of the application, what are the conditions under section 94, 95, whether all has been complied with or not. I will come to that report, which is required to be submitted by RP, and later on the actual case would be admitted for insolvency resolution process. So presently, maybe then there are some cases like even Delhi High Court has given an order that the RP's report under section 99 of the code, that has to be provided to the debtor, because he has a right of say. If a RP gives a report and the report is not provided to the debtor, then he would not be able to represent before NCLT against his insolvency. So that has also been held by Delhi High Court in one case. I was trying to find out the name, but then I would definitely, in my second session, I would find out that name. But so presently the scenario, as far as our understanding is concerned, simply an application would not mean CIRP proceedings or liquidation proceedings. I think, Ankit, we can go ahead, and then we can, other questions we can take at an appropriate time.
Yes.
So the jurisdiction is a very, very like kind of see, like very confusing at this moment, whether the applications can be admitted or not. So this is again on jurisdiction, because for the purpose of section 60, the NCLT constituted under section 408 of the Companies Act. This is a jurisdiction. This is this is the definition of the adjudicating authority. Or in cases other than subclause 1, the DRT established under subsection 1A of section 3 of the Recovery of Debts and Bankruptcy Act. So this is a jurisdiction. So then there was a question like why this, when it was effective from 1st of December 2019 and December 2019, and now we are in 2021. So what happened in 2 years exactly? So for 2 years, not much of activities was done in this case, as this the constitutional validity of this kind of amendment, where the personal guarantors were segregated with other individuals in the country, was challenged before a Supreme Court. And there were other arguments, and that was argued by many lawyers, including the lawyers of Anil Ambani. One argument was that when the creditors in a resolution plan, they change the terms and conditions of the contract, because this guarantee is a matter of section 133 of the Contract Act. In case that is changed, the terms of the contract is changed without the consent of the grantor should not be responsible for that. But then the Supreme Court held that section 31 of IBC makes it very clear that the plan is binding on the grantor also. So because since the section 31 or the entire IBC code, it overrides other, wherever there is a contradiction, the IBC overrides. So section 31 would override, and whatever changed terms and conditions as per the resolution plan, that would also be applicable on grantor. The second argument before the Supreme Court was that once a resolution plan is approved, that means the finality has been achieved. So therefore, the grantor also gets discharged from the liabilities, and it was also negated by the Supreme Court. And the other was the principal borrower is discharged and the grantor is not discharged. So that was also negated by the Supreme Court, and this was done on 21st of May 21 in the case of Lalit Kumar Jain versus Union of India. So it is actually not Lalita, but it is Lalit Kumar Jain. So now coming to the real process, we have discussed that this particular law is applicable presently on individuals. We have also discussed very clearly that this law is applicable to all individuals whenever it is notified. So it is actually important that all professionals definitely would have to go through this law whenever it's notified. So earlier the better. The law has been made in 2 stages. Anyone who has the knowledge of CIRP and liquidation process, it is similarly, there are 2 stages. One is the insolvency resolution process and the other is the bankruptcy process. Now the bankruptcy is a little harsh. So therefore the chance is given, first 6 months is given to the individual for resolution. And once the resolution is not achieved, then bankruptcy. The bankruptcy is like liquidation in the case of CIRP, and individual insolvency resolution process is just like corporate insolvency resolution process like CIRP. So there are section 94 to 120 deals with the resolution, section 121 to 78 that deals with the bankruptcy process. As I said, that we would actually be dealing with this clause by clause discussion, and also kind of a debating on the various questions which comes in between. So therefore, this process of complete learning of the insolvency resolution process will take 2 sessions, and also for bankruptcy, it will take 2 sessions. And then thereafter, we would focus on specific questions from the debtors, why the debtors would come out, why the debtors would come forward for their own insolvency, why the debtors should not file their own insolvency and their own bankruptcy. And then there are, in fact, benefits that we have seen in the entire law and the regulations, that it actually becomes beneficial for a person who actually is suffering from some kind of financial stress. He has given guarantee to various loans. He is presently commercially, he's incompetent because of various defaults on his head. So therefore, he would like to get some discharge so that he owns businesses, he becomes director, he becomes otherwise eligible to do businesses after this complete discharge. So let's start with the insolvency process, insolvency resolution process for personal guarantors. So this application for the insolvency resolution process can be made by the personal guarantor himself. We call him debtor in short. He's a debtor. So, or the application can be filed by the creditor. Nobody else, or the debtor and the creditor both can file the application. So now the application by debtor himself, that is governed by section 94 and rule 6, where the individual can file his own application. As I'm trying to again say, that you would see when we will talk about bankruptcy, that how it is beneficial to all those persons who have some financial stress, how they will get discharged in 1 year, exactly 1 year of the commencement of bankruptcy. It is not like earlier insolvency and bankruptcy laws in this country, where this bankruptcy would continue for 20 years. But this is not a law. This is whether the creditors are getting any asset or not, whether the creditors are still tracing the assets, whether the creditors are still fighting some of the litigations, but the debtor will get discharged maximum within 12 months or earlier if decided by the creditors, or maximum within 1 year the debtor will get discharged. That is the highlight of this particular law, because the primary, like incidentally, I was also member of the working committee constituted by IBBI for where the responsibility was given for implementing this individual insolvency in India. In that particular process, we actually have gone through a clause by clause discussion and have also discussed. So for individuals, the most important is that it is about human. It is about life of a human. It is about economic life of a human. So it is not about recovery. It is absolutely about the quality of life of a person who has undergone some kind of financial stress, some kind of losses in the past. He endeavored to do some business. He gave personal guarantee to a loan which is taken by the company that he floated, but that company lost money. So therefore, he also has a right to restart his commercial life. The primary focus of the discussion was this, and it was never the discussion of recovery from individuals. The primary focus was this. However, of late, when the CIRP was seen for the last 4.5 years in the country, there was a kind of discussions that the government has taken the business from the companies. The promoters have been taken away their businesses. But how about their personal assets? How about their personal life, which is still king size? They're still king size life. So that was a kind of criticism coming on the insolvency law. Then the government thought that it is appropriate that while we take away their company, we also make sure that all those promoters who have caused losses, they should also become bankrupt or they should settle their dues. So therefore, the government, in fact, notified this law for personal guarantors. Now, there will not be any political pressure on the government, that the government has not done anything against those promoters who have caused huge losses to the exchequer or to the banks because of the liabilities not paid. So therefore, the government, in fact, not only notified this, after this Lalit Kumar Jain order in the month of August, in fact, the Department of Financial Services in the Ministry of Finance, they have even directed the public sector banks to proceed against the personal guarantors, so that there should be a kind of sense in the market. There should be a complete understanding in the market that the government is tough against those promoters, and not for recovery, but just making them bankrupt. Nobody would be able to say in future that you have taken the company back from the promoters, but the promoters are still richer. The government can definitely say that the promoters are not richer. They have been adjudged bankrupt by any court of the law. So they are bankrupt. So that means that there is complete process has gone through. They have no asset in their own name. Whatever asset was there, it has been taken away by the bankruptcy trustee. So therefore, nobody can challenge the insolvency law, the kind of effect of the insolvency law. So that's a very important part of it. That this was from the government part of it. This was from the bank's part of it. But then when we come to the debtor, it is also very, very useful. We'll discuss further. So because I said that this is a session which is clause by clause, most of the professionals are presently connected with us. So the application can be filed by the debtor in Form A as per Rule 6.1. Application fee is only 2,000 rupees. The application has to be served to every financial creditor and the corporate debtor. Application will also provide information about associates. The word associate is very important because we associate, like as we say related parties in CIRP, the word associate is also important like related parties in CIRP. Assets of the grantor, immediate family, annual income, directorships, businesses, debts, excluded debts, all this information has to be provided by the debtor in the application. The particulars of the immediate family has to be given. Particulars of the resolution professional, if appointed by the debtor, along with the declaration and signature of the RP. Along with the declaration and signature of the RP, that is a part of the application. So in case the signatures are not there on the application, the declaration of the RP is not there on the application, then the RP would be appointed by NCLT from the panel provided to NCLT by IBBI. So in case the application is not signed by the RP along with the declaration of the RP, then later on, you cannot give, the debtor or creditor cannot give the name of the RP. Then the RP would be picked up from the panel. So there are various documents that I have compiled all this, looking into the form, looking into the rules, looking into the regulations. The documents which are required to be attached are the income tax returns, wealth tax returns, statement of affairs, GST returns, bank account statements, documentary evidences of the assets. The application has to be filed in an electronic form with such facilities available. Application can be submitted, cannot be submitted if a process of resolution or bankruptcy is undergoing. That is, of course, if already some resolution is going on, if already bankruptcy is going on, no application can be submitted. Application cannot be submitted for excluded debts. If a person says that I have a debt and that debt is excluded, we will come to the definition of excluded debt. That also means that the application cannot be submitted. The copy of the application should be given to the RP also. And if not given earlier, it has to be given within 3 days of his appointment, because in this particular case, I would say the RP is appointed before even the application is admitted. In individual insolvency, RP is appointed before even the application for insolvency is admitted by NCLT. A copy of the application is also required to be submitted to IBBI for record purposes, and the proof of the submission to IBBI has to be attached with the application. So this is with every application nowadays. Even if you file an application for CIRP, that application would be submitted to IBBI and that evidence has to be also attached. So very clearly, all this detailed requirement for application is discussed. So Ankit, is there any question as of now? Because we have seen that the debtor can also file an application. So any questions so far? Otherwise, I will actually complete the application by the creditor also. Then we can seek the questions.
With respect to this issue, I don't see any questions with respect to applications. Specific questions for application are not there. And I think one question that you can answer.
Anything which comes in your mind, like anything which you feel as an audience, any question which comes in your mind?
So one question that has come up now is that RP appointed before admission, whether the required forms to IBBI are to be submitted before admission. So IBBI compliance with respect to RP appointment is one question.
No, that has to be done. Yeah. RP is appointed, and the status of the RP is RP, even if the application is not admitted. So he has become RP, although there is a question which is still not resolved. In some of the cases that we feel that the RP was appointed in the first or second hearing by the NCLT, then RP gave his report under section 99, the proceedings went on. And finally, it was decided that this is not an eligible case for starting insolvency of the debtor, and that application was rejected. Now, the question is, RP has worked for 2 months, 3 months, 4 months. RP has also worked with the debtor. RP has also submitted a report under section 99. RP was also present in all the hearings, whatever has, because he can also be asked any question at any point because he has submitted a report, and there can be any challenge on the report. So RP has also spent money on the lawyers. So who will pay this fees when the application is rejected after the appointment of RP? That's a question. Everyone, whosoever has been appointed as RP, must be discussed with NCLT. Like if the application is rejected, I'm saying, see, based on the natural justice, I'm not even sure whether this cost can be loaded on the debtor, because he will say somebody filed an application and that was a wrong application. Now that application is rejected because I proceeded against. So why should I pay? It should be paid by the person who filed the application. It should be paid by the creditor who filed the application. Why should I pay the fees of the RP? Because I'm not, I'm an innocent person. Because had I been a person in default, then definitely my insolvency would have been started. So therefore, I am sure that this money would have to be paid by the creditor who filed the application or debtor who filed the application. That means that this part of the fee of the RP would have to be paid by the applicant, but that provision is not there in regulations, that is not there in the rules, that is not there in the IBC. That's a complete blank, like how this process has been established. Appointment of the RP first, and then case gets rejected. So case gets rejected, and to my understanding, the applicant will pay the fee of the RP for this period. So I actually somehow don't feel very comfortable that the most of the insolvency professionals who are getting appointed by the banks, the realization of fee would actually be very difficult, because the banks would say that we haven't got anything, and the fee, of course, is decided because normally the banks say that it will take 6 months, but that 6 months will start from the date of admittance of the application. Now, in case the RP started working today and the hearings continues for 3 months, 4 months, 5 months before the case gets started, then the 6 months will start. In fact, RP has been working for 4 months plus 6 months, 10 months. So RP, the insolvency professionals should be vigilant in accepting appointments from the creditors where they are stipulating total period of the fee would not exceed 6 months. But that is incorrect. Actually, that is incorrect. The period would actually be much more than 6 months because of this appointment of RP, starting of the duties of RP before even the application is admitted by NCLT, before even the insolvency resolution process is admitted by the NCLT. So that part is ambiguous, and it needs the jurisprudence. So whenever you feel that the application is getting rejected, you actually can make a request, you can make a pleadings before the NCLT that while you are rejecting, you should also provide for the payment of the fee of the RP who's been working for the last 4, 5, 6 months. So that's what is my suggestion and practical understanding.
The second question, and that I think is already litigated also, that if an application is pending for CIRP or liquidation proceedings are pending. So there are two cases now. CIRP application is pending for a CD, and we're talking about the personal guarantors to that loan or that borrowing. In that case, I believe the application will be submitted before DRT because the application is still pending and it can be filed. There is no embargo on it. If the application is pending, if the CD is going through a CIRP or liquidation proceedings, that there also the law is clear that one can go for the insolvency proceedings against the personal guarantors.
Yes.
Thirdly, in case the CIRP or liquidation proceedings have concluded, then also I believe the borrower can go or the creditor can go as long as the debt is pending.
But then in that case, it will go to DRT. In case the CIRP is concluded,
it will not go to NCLT. Yes.
Resolution plan is approved and implemented, then it will not go to NCLT, it will go to DRT. Or
so any
liquidation, yes.
So any amount which is required to be there, like now if you talk about CIRP, 1 crore is the limit that has to be followed. Now, in case of individual insolvency, is there any limit to which one has to stick to?
No, see, like the original law says that it is 1,000 rupees and it continues. There is no change so far.
So in that case, if somebody has given a loan, the outstanding is less than 1 crore rupee.
Then 1,000.
1,000, I understand. So CD, against the corporate debtor, the loan is outstanding for, say, less than 1 crore rupee. The CIRP application cannot be made. The person can actually invoke personal guarantee and take the guarantors to DRT.
Absolutely. So anywhere where the creditors are not able to start CIRP, they can still invoke, and they can still invoke the personal guarantee, and they can still take the person to DRT for the individual insolvency and bankruptcy.
Right. And there are other questions with respect to, are there any other proceedings that might be already continuing in the DRT which might hamper this proceeding of insolvency? Say maybe a SARFAESI case has already been applied for, or a SARFAESI case is going on. SARFAESI action was initiated by, say, the financial creditor. The stay was obtained by the owner of the property, let's say. And can a simultaneous case go on for insolvency of the corporate debtor of the personal guarantor?
Like as far as the surface is concerned, that is only for enforcement of security interest. So wherever there is a security, that enforcement is governed by the surface law. So that has got nothing to do with the personal guarantor's responsibility or liability to pay. Because see, when we talk about the individual properties hypothecated or mortgaged to banks or creditors, that is a separate law. That's a surface law. So what we are trying to say that we are trying to recover from all those assets of individual which are not mortgaged. That is the reason that we are trying to make him bankrupt, or we are trying to ask him to resolve, otherwise we'll make you bankrupt. So
Right.
that is where we actually go to RDB Act. RDB Act is the act where we file an application against personal guarantor for recovery. And the process is that the application is filed, then his assets are traced, and the list of assets are provided to the DRT. Then the DRT attaches those assets, and then the recovery officer, it goes to recovery officer. Then the recovery officer take the possession of those assets and sell and then distribute. That's the process under RDB, and that's the process before DRT. So
And
any such proceedings pending before DRT may be surfacey for enforcement of security interest. Maybe it is owned by the company, or maybe it is owned by the individual. That would not impact this bankruptcy or insolvency application before DRT. Even if there is a stay on, the enforcement of security interest, which is owned by the company or owned by the individual, then also there is no bar. The only three conditions that we have to see, that there was a personal guarantee, the guarantee was invoked, and the individual could not pay it. These are the only three conditions, no other condition. And then second is jurisdiction. Very simple.
is there any difference in the difference likewise as financial creditor, operational creditor in this case, or
No,
all creditors are the
there is
same?
no difference. All creditors are the same. Application by a creditor wherever the individual has given guarantee. Wherever the individual has given guarantee.
Are there provisions for replacement of credit of the RP by the creditors?
So during insolvency resolution process, which is considered to be 6 months, there is no procedure of replacement by the creditor or by the debtor. When we say replacement, even the debtor can apply that I don't need this RP, or the creditor can also apply I don't need this RP, but then there is no possibility of suggesting a name either by debtor or by the creditor. In case the debtor or the creditor, they both are able to establish that the RP that we appointed is not working, or is not able to work, or is working against the law, then they can make an application to make somebody else as an RP, but they have no choice of recommending a name. Then the NCLT will pick up, or DRT will pick up from the panel. However, there are repayment plans. There are some repayment plans where even the business of the personal guarantor would be managed in some kind of manner, where the business of the personal guarantor is also kind of monitored as per the repayment plan. In that case, when the repayment plan is approved by the creditors, then the creditors has a power that they would propose a different RP for the purpose of monitoring of repayment plan. After the repayment plan is approved by NCLT, there is only one provision where the creditors can suggest another name, and that name would be for an insolvency professional who would monitor the repayment plan. Now, the repayment plan can be of many kinds. The repayment plan can be that this particular property would be given on rent, and the rent would be under the monitoring of a particular person, and that particular person can be changed. That RP can be changed. So that rent would be paid to the creditors, or the business of the individual, and that business would be monitored by the insolvency professional as per the resolution plan, as per the repayment plan, sorry. So this way, the creditors has a power that for future monitoring of repayment plan, they can propose a different name of the RP.
So correct me if I'm wrong here, that when we talk about individual guarantors to corporate debtors, we are only talking about corporate debtors in the meaning specified in CRP regulations, that is LLPs and companies, partnerships, other trusts, other ways of making or constituting a business are not covered. So if there's a trust, so nobody can still file an insolvency against the individual guarantors to a trust or a loan taken by a trust.
No.
Then the second question is, there is a stay by CR by Supreme Court with respect to any CRP proceedings. I don't think that hampers the individual proceedings, as we have already discussed. These are separate proceedings, and one can go to DRT and say that okay. In that case, the question is that if in CRP process is stayed by Supreme Court, will the jurisdiction be NCLT or DRT? So
see, when the process is stayed, CIRP is stayed by Supreme Court. So stayed means like we actually have to see the process normally is stayed only for a particular reason. The RP continues to be RP, and the process is only stayed for some kind of other reasons. My understanding is that even if the CIRP has already been started, RP is continuing, the Supreme Court has not cancelled the CIRP proceedings, then it will be considered that the CIRP proceedings are on. Then in that case, the jurisdiction would be NCLT and it would not be DRT. Just a stay does not mean cancellation, does not mean withdrawal of the CIRP process. It's only a stay. Somebody can only say that while this application is pending before the Supreme Court, the individual insolvency should not be admitted. That can be an argument, but it doesn't change the jurisdiction.
There's a question that the RP appointed for CD, can the RP also be appointed for individual insolvency, or it has to be a different person?
Well, the regulation says that it has to be a different person. It is very clearly that anyone who was the RP or the liquidator of the CD should not be the RP or bankruptcy trustee for the personal guarantors. That's what the regulation says.
And let's say there are 3 personal guarantors to the CD. In that case, can the same RP be doing the insolvency proceedings for all the 3 people?
Yes, I think this is the main, the banks are negotiating only on this point, that there are 5 personal guarantors in this company, and the creditors are the same, and the family is the same. You would have the discussions with the same family. So they are negotiating the fee, and to a great level, because I have seen people taking 4 cases of the same family, same CD, for a fee of rupees 1 lakh per month. And to my understanding, it is viable, because when you will complete this session, you would see that the RP in the case of resolution process has lesser duties. It is less time consuming as compared to bankruptcy. It is less time consuming as compared to the CIRP, because in this particular case, there is no responsibility with the RP to trace assets. There is no responsibility with the RP to continue the business of the personal guarantors. There is no responsibility of the RP to protect and preserve the assets of the grant debtor. So these responsibilities are not there. The RP is only conducting a process. And in case the repayment plan is acceptable, okay, no, it's not acceptable, the matter finishes. So this process of resolution, bankruptcy is difficult. Bankruptcy, you will have to collect the asset, trace the asset, take the occupation, possession, sell. Bankruptcy is much difficult. When you will see the bankruptcy, it is actually more difficult than liquidation, because in the case of individuals, you would have no information about the asset. You might have to go for the detective agencies. And then there are hardly any estimate that you would be able to make. How much investment you can do, how much expenditure the creditors would incur, how much you would be able to recover from these assets. You see, like in case you appoint a detective agent, and finally he comes out with a report that there is no asset that I could find, and then like all these expenditures would be a load on the creditor or applicant. So my understanding is that the fee and the source of the fee for insolvency professionals would be a very, very challenging thing. Because when the banks would see that there is hardly any chances of recovery, they would shy making any payment to the individual to the insolvency professionals.
And do you think that the RP who is involved in resolving all these individual insolvencies has to be accountable, or rather in the long term, those RPs will be preferred by banks who are able to understand if there are any assets that are realizable as compared to those who are not able to uncover any assets that might be realizable from the personal guarantor, yeah. So, because end of the day, there will be maybe some assets which are not in the personal guarantor's name, and the personal guarantor might still be enjoying those assets. So, how do you take care of those?
I think, Ankit, you have touched a very important point. It is the first scene that I have seen in the case of individual bankruptcy. In case the bankruptcy trustee or has actually been found conniving with or doing something which is unlawful, there is an imprisonment for the bankruptcy trustee also. I will come to that, and that's very serious. That in case there are evidences that there was an asset which was in the knowledge of the bankruptcy trustee, and the bankruptcy trustee ignored that asset. Later on, somebody found that asset and creates an evidence that yes, the bankruptcy trustee worked against the interest of the creditor, then there is an imprisonment. So responsibilities are there in bankruptcy, not in the resolution process. So I would only advise my professional colleagues, you should be very, very careful in taking the cases of bankruptcy. Insolvency resolution process is very cool. It is an experience in itself. So the only thing is that not much of work is also involved. Only the first few cases where the formatting and everything is being done. So you may find it difficult because there is hardly any, there are multiple reports which are required to be given by the RP. And there is no format available for those reports. Everyone will make different formats. Everyone will get questions from the NCLT that you have not covered this, you have not covered this, you have covered this unnecessarily. So that kind of things will evolve gradually. But presently, there are many reports which are supposed to be made by RP and no formats are available. The formats has to be crafted by the insolvency professionals themselves.
Let's proceed then to the next slide and to the further topics.
Okay, so the application by the creditor, we have seen the application by debtor. So the application by the creditor is almost similar, but the only difference is the creditor has to give a notice, 14 days demand notice under section 95(4) subclause B, and there is a form also, form B in the rules. So before any application can be submitted to NCLT or DRT, there has to be a 14 days demand notice to debtor by the creditor. Application in this case by the creditors would be submitted in form C of the rules. Application fee is only 2,000 rupees. Application can also be filed jointly by some creditors, because in some cases I have seen that there are multiple creditors in a case. Everyone joins together in COC that let us collectively go against the personal guarantors. Why collectively? I think there is a question of fee. In case there are 6 members of the committee of creditors, all are creditors, all are expecting some recovery from the personal guarantors, they should file an application, they should become a joint applicant, and so that they are able to share the fee. They are able to share the fee, because I have not seen any provisions where it is mentioned that the fee would be contributed by the creditors. So everyone presently, we are all going ahead accepting our appointment based on an applicant. No applicant, for example, applicant is State Bank of India, who says that I will pay you 1 lakh of rupees per month for all these 4 cases. Now, when this insolvency starts, is that the responsibility of the State Bank of India to give the entire 1 lakh of rupees to the RP? That's a question. Because in CIRP, it is the committee of creditors. In this insolvency, there is no committee of creditors, it is a creditors. It is a list of creditors. There is no committee constituted during insolvency process. Rather, there is a committee of creditors in bankruptcy process, which is a completely different law, different section, different regulations, different rules.
Insolvency resolution process, there is no committee of creditors. It is only a list of creditors, or it's a meeting of creditors. It is never called as a meeting of committee of creditors. Now the question is that is the applicant only responsible for making payment of fee, or all the creditors will contribute for it? When other creditors will understand the case in 1 or 2 meetings that there is hardly any possibility of recovery, why would they contribute? Then the applicant would contribute the entire money. That's also not the jurisprudence. Jurisprudence in the case of CIRP says that the CIRP cost would be contributed by all the creditors. And that is what is the jurisprudence in the case of CIRP. However, in the case of individual insolvency resolution, this is again has to be evolved. My understanding is that all the creditors, they would contribute. So even if we agree with State Bank of India for 1 lakh of rupees, whether State Bank of India would contribute or would be responsible to contribute, or State Bank of India would say that I am only 30%, so I will only contribute 30,000 rupees, and the rest of all that you have to recover from the other creditors. And the other creditors might or might not pay, and that becomes a litigation for a small amount. Because the amounts are smaller, litigation cost would be higher. So all these are precautions that I'm going to caution you. How would you handle this? I'm talking about 1 lakh of rupees, but there may be cases where the only fee is 50,000 rupees per month. And in those cases, what would be the ultimate recovery of your fee? So these are the questions. Of course, the law will evolve, but still my understanding is that the applicant who is settling fees with you is not responsible for making all the payments. He is only responsible for making all the payments in case the application gets rejected by NCLT. But once the application is accepted, insolvency resolution process started, then all the creditors should be liable to pay for the expenditure and the fee. In this case of application by the creditor, the application must provide the details and the proof of debt, details and proof of default, evidencing that the debt was not paid during 14 days period. Application again to be served to the debtor, grantor, and the corporate debtor. Application will also provide information about the assets of the grantor, immediate family, annual income, directorships, businesses, debt, excluded debts. All this information has been gathered from the application forms. Again, the RP has to give a declaration. RP has to sign the application. It was when I was appointed as the RP for Anil Ambani's personal insolvency, the application at that time, that was first few applications, the application was not signed by me. And despite various requests by State Bank of India to NCLT said, there is no provision that I can appoint your recommended RP. That RP which you have recommended, that RP should have signed the application along with the declaration. So when the Anil Ambani's application was admitted, then the RP was picked up from the panel which is provided by IBBI to NCLT benches. So this is very careful scenario that when a creditor files an application, the application must be signed by the RP. Otherwise, the recommended RP would not be appointed. Documents which is required to be attached to the application is demand notice, income tax returns if available, wealth tax returns if available, documentary evidences of the other assets if available with the creditors. Application to be filed in the electronic form. And again, as I said, that application copies are supposed to be given to IBBI as it is required in all other CIRP cases also. So we have finished this part of it, like the application part of it, jurisdiction part of it, and there are various questions regarding the fee, everything that has to be, that is all discussed. Should we discuss excluded assets? So we actually should make this session for only 1.5 hours. Ankit, what do you say? Because we said
I agree, it should not be more than that. So we can stretch it till say 12:30.
Yeah.
With the permission of all the participants. This is a time-taking topic, so I think we can do that.
So excluded assets are a very important concept. Like in case like when we say excluded assets, Section 79 deals with it. It means that in the resolution process or in the bankruptcy process, these assets of the debtor these assets of the guarantor would not be used for repayment of debts. Now, what are these? Unencumbered tools, books, vehicles, and other equipment as are necessary. The word necessary is very important to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation. Second, unencumbered furniture, household equipment, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. Any unencumbered personal and ornaments not exceeding a value of rupees 1 lakh of the debtor or his immediate family, which cannot be parted with in accordance with the religious usage. Rule 5 very clearly says limit is 1 lakh only for religious usage and not only for the debtor. It is also for his immediate family. Immediate family has already been defined. It is the spouse, dependent children, and dependent parents. This is the immediate family definition. So in case of a debtor, the jewelry, anything more than 1 lakh of rupees, whether in the name of himself or herself, in the name of spouse, in the name of dependent children, or in the name of dependent parents, all the jewelry will be taken away by the bankruptcy trustee, leaving 1 lakh of rupees ornaments which are required for religious usage. That can be kada for a Sikh religion, that can be Mangal Sutra for a married woman. So these kind of religious usage, only 1 lakh of ornaments can be left with the debtor. Everything else will be taken away by the bankruptcy trustee. Any unencumbered life insurance policy or pension plan taken in the name of debtor or his immediate family, irrespective of any amount, insurance policy, life insurance policy, or pension plan which somebody has been subscribing to, that would not be taken away by the bankruptcy trustee. Finally, an unencumbered single dwelling unit owned by the debtor having following value. In case the debtor is living in urban area, maximum value of that house should be 25 lakhs. In case the value of the house is more than 25 lakhs of rupees, so that house would be taken away, or the debtor would be given an opportunity that he should pay the balance amount, or any of his relatives pay the balance amount. Otherwise, the debtor can be left with 25 lakhs of rupees to buy another house. If he is living in the rural area, then the maximum value of the house that he can retain is 10 lakhs of rupees, and these values would be based on the circle rates of that area, only based on the circle rates of that area. And also, in fact, we made certain detailed rules, like how much square feet, how much, all those were not notified. Maybe that the government thought that let that be settled by the jurisprudence. But presently the law is, the rural area is defined as per National Rural Employment Guarantee Act, and urban area is any other area which is not defined as rural area. So these, now when we talk about excluded assets, the word necessary in two situations regarding tools, vehicles. So if somebody is a bankrupt and he has a S-class Mercedes, you can't consider it as vehicle which is necessary to the debtor. Vehicle means the minimum vehicle required for living a life. Vehicle doesn't mean S-class Mercedes. So he cannot invest all his leftover money in S-class Mercedes because that is not necessary. Similarly, he cannot have the household equipment and household furniture made of gold because that is not necessary. So nobody can take the advantage of these clauses because the word necessary is very clearly written. So the necessary is something which is necessary for satisfying the basic domestic need of a bankrupt and his immediate family. Necessary to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation. So in case he is a bankrupt, does he need S-class Mercedes? No. So that will be taken away. But that's not a vehicle which is necessary. So here it's a very important is the excluded assets. Going forward is the excluded debt. Now, when we say excluded debt, I explained the meaning why excluded debts are important, because any asset which is excluded, any asset which is mentioned in section 79 cannot be taken away by the bankruptcy trustee, or
cannot be used for repayment plan. So this is what is excluded assets when we come to excluded debts. So when we say after the bankruptcy process is over, or whenever there is a default, the application can be filed by the debtor or the application can be filed by the creditor. Now, in case like in international scenario, you probably would say that if I have, if I cause an accident, in a case of motor vehicle also, if I cause an accident and I'm not insured, and the court decides that I'm supposed to pay 40 lakhs of rupees to the injured person, so I cannot consider that as a debt for the purpose of my filing of application. So these are excluded debts, because the liability to pay fine imposed by a court or tribunal, I cannot say that the court has imposed, if the court has imposed a fine on me, so that's a debt and I can file an application for insolvency. No, that is not a eligible debt. That debt is excluded under section 79. So no application can be filed if I have a liability to pay a fine which is decided, held by a court or tribunal. Second, liability to pay damages for negligence, like I gave an example of Motor Vehicle Act, nuisance or breach of a statutory, contractual or other legal obligation. So in case I have a kind of penalty for any kind of nuisance that I have created, or breach of statutory, contractual or other legal obligation, I'm not saying, because see, there is a difference in damages and the actual liability. There is a difference in damages and actual liability. When I say my income tax dues are my liability to pay taxes, when I say that I actually I caused a loss to out of my negligence, somebody else's house got demolished, out of my negligence I hit and somebody else's car got damaged. So those are damages which are not excluded. However, my income tax is my commercial liability, my GST is my commercial liability, because these are not damages, these are taxes. Even if I am statutory, if I'm not paying my taxes, that may be a breach of my statutory responsibility, but that is not damages. Damages is different, tax and penalty is different. Damages is different, tax and penalty is different. So please understand that whenever I'm saying that the income tax liability, GST liability, including penalty, all those would be considered as waived. However, in case I convert my prosecution, if I convert my prosecution into some kind of damages, that would be considered as an excluded debt. So it is not possible that I have an imprisonment, I have a charge on me where I can be imprisoned for 3 years. And now I say that I want to convert this into damages. So the court says that, okay, you pay 1 crore rupees. After that damages order, where I am converting my imprisonment into damages, and then it cannot be considered as a debt for the purpose of insolvency. Third, liability to pay maintenance to any person under any law for the time being in force. Now, this also includes maintenance under a marital act, under the Marriage Act. In case the court says that under a divorce case, you are supposed to pay maintenance to child or to your spouse, so that liability also cannot be excluded. So even if I go through 12-time insolvency, that liability I'll have to pay. I will have to pay the maintenance to spouse or to the children. Liability in relation to a student loan. I mean, this is well thought of, because when a person takes loan of 1 crore of rupees and going to America for study, at that time his net worth is 0. So he goes, he takes a loan, and thereafter, after qualification, now he has 2 options. One option that he can pay for this loan for 15 years and he can live miserably because the salary is lesser and his loan is very high. Or second option is that he files an insolvency. Within 1 year, he would be free from this liability, and then thereafter he would join a job. So that options have been clearly taken away from such people who have taken loan at a stage when their net worth is 0. Because the student loans are given
when their net worth is not really high. Any other debt has to be prescribed. That's a power taken by the government that they can provide any other debt which can be excluded debt. So very important two concepts, excluded assets and excluded debts. So in case any question on this, I think we can take up these questions on excluded assets and excluded debt. So no application can be filed if the debt is defined under section 79. If I file an application for any kind of damages, no application can be admitted. If I file an application to get rid of a fine, no application can be admitted. If I file an application for getting rid of my maintenance order, which I'm supposed to pay 2 lakhs of rupees every month to my spouse, not admitted. Loan, student loan, not admitted. So Ankit, now I think we need to have some questions on this particular, because this is a very important part of the.
I don't have any questions on the question box yet. I can look at the fact if any questions come in, and I think it's pretty clear to me that these are liabilities which are personal in nature, which have a certain character, which due to which these have been excluded from any possible waiver through an insolvency process. So any other debt as may be prescribed? I don't think anything has been prescribed so far. That's a question that has come, that has anything been prescribed in rules for any other debt?
No, there's nothing. No, nothing has been prescribed so far.
So that's one clarification that is good. Will an arbitration award which turns into a decree qualify as a debt? I believe yes. It's a liability, and it is not an excluded debt at all.
No, it's not an excluded debt because it is not damages for negligence. Yes. The damages for negligence is something different. Penalty for not paying income tax is different. Penalty is different, and the similarly, arbitration award is a commercial debt.
Then some people have a question that what about ancestral assets? So I don't think there's anything called ancestral assets when it comes to excluded assets. Only those assets which are listed here are excluded, and there's nothing with respect to whether you've got something from your ancestors or it is a self-built property. I don't think there's a differentiation with respect to that.
There is no difference between self-acquired property or inherited property. All properties in the name of the debtor can be used for repayment and can be taken away by bankruptcy trustee.
Uttam Agarwal ji is asking that if somebody has a dwelling unit worth 1 crore rupee in urban areas, how will it be dealt with? So I think the point is that there is a process that you were discussing earlier, wherein one can then acquire a smaller property, and that option will be available to that person in the course of time.
Yes, that would be available, because see, as I said, that this when we made that a separate complete document, it is still there in the draft, you would see, but finally it is not notified. So in that draft, what was uploaded by IBBI, there was a complete process. The right of first refusal was also given to the debtor regarding his house where he's living or his family is living, but that has not been notified neither in the rules or on the regulations. There was a provision that he have a right of first refusal and he can ask any of his relatives to purchase that house and pay the balance amount, but that is not notified so far, because maybe when it comes to bankruptcy part, then it may be, because presently there is no case in the bankruptcy process. Everyone is under the resolution process, because after the 6 months, then the bankruptcies will start. So there is no application in India which is presently having a bankruptcy. There is no bankruptcy proceedings pending, but then within the next few months, you would start the bankruptcy applications also will come up.
Anil Mittalji has a recommendation. He says the way the amount is fixed for dwelling unit, it should also be fixed for cars, so that your S-class Mercedes or C-class Mercedes or E-class Mercedes, you can't differentiate between what is necessary and it is not subjective then. So
no, I think the wording which is very clearly written, or for the purpose of his employment, business or vocation, personal use. Like if somebody is actually using that car and earning some money by just giving that car on rent, then definitely it can be retained. But like for a personal use, it cannot be. I'm reading it again for the purpose of everyone's understanding. If that Mercedes is being used for employment, business or vocation, and he can definitely say that that's my income, then he can actually say that this is my income, so I will definitely earn out of it in case you can accept. And in case it is not acceptable to the creditors, then the creditors can say that this is not necessary for your personal use. So the personal use is different, but or for the purpose of his employment, business or vocation is different.
So, how the process of valuation for the house and jewelry is to be adopted. So, I think you can choose to appoint a valuer in the whole proceedings to understand the values, and that's how I think the whole process will be taken up.
Yeah.
Um, Circle rates. So yeah, circle rates is one way of seeing the value of dwelling units, but I believe a full-fledged valuation is a better way than a circle rate valuation.
No, for the purpose of this dwelling unit, the circle rate has been very
Yeah.
clearly said that
So
it will
that's
be
it.
valued based
That's
on
it.
circle rates.
So it's only for the circle or for the primary valuation. Yes.
Right, right.
Mm. So then the question is that how do you differentiate that what is owned by that person, what is owned by his family members? That's again a question of fact. Like it's all depends on what documents are available, what are the evidences available. Of course, if you talk about jewelry, maybe everyone will say that all the jewelry that I have is just my maybe some belonging to somebody who is not a guarantor. But that's the challenge, that you then document that what is the ownership proof that is available with respect to all those cases and so on, perhaps. I
No,
believe.
I also feel that once this litigation would start,
Mm,
if someone says that I had declared jewelry worth 50 lakhs in the voluntary disclosure scheme of income tax, or somebody says that I had filed my wealth tax returns where my jewelry was at that time 500 grams, and now I don't have that jewelry, I have sold everything. So I believe the it would not be considered as uh, acceptable argument that I have sold and used everything, and then the provisions regarding not disclosing the full assets, those would be applicable, and the prosecutions can be started that this particular debtor is not handing over all that what he declared, and he is not even showing any evidences of sale. He's not even showing any evidences of consumption. So these can be one part of litigation which will have in future, in case somebody finds evidences that this person had declared in the wealth tax returns 1 kilo of ornaments. So that kind of litigation would go definitely.
One will also, of course, watch out in the future that in case somebody has gone through bankruptcy process, I believe that it is something that we can assume that if that person immediately starts, gaining a lot of wealth without paying taxes or without showing that as income that he has earned in future, that will again be something that will be subject to challenge. Pawan Singhal has another remark. He says that. The will the excluded debt continue after declaration of bankruptcy? So, Pawan, that's the fact that excluded debt will remain and it will
Yes.
not get waived off in any circumstance whatsoever.
So as I said that the excluded debts would continue even after he gets the discharge. He will get discharged from all other debts. And when we actually go to the discharge, there is a different discharge available after the repayment plan is approved and implemented, and the different kind of discharge is available after the complete bankruptcy process. And when there is although small difference, but it is very, very significant to understand the difference between the discharge after bankruptcy process and discharge after repayment plan is implemented. Some of the important definitions that we must understand, although we have 10, 12, 30, I think let's conclude today because otherwise it becomes boring. So we again connect with everyone same time next Sunday, and we will try to conclude, because in like beginning there are a lot of questions, and maybe in when we again go with the flow of the document, the law is complicated. There are a lot of questions, not all the eventualities are covered in the law or the regulations or the rules. So there will be a lot of things which actually will come out of traditions, like CIRP cost contribution is also a tradition. It is also a kind of judicial, based on judicial pronouncements. Similarly, in this case also, but the only difficulty that the only amount of 50,000 rupees getting diverted into bifurcated into 6 creditors. So that actually will be Herculean task to get collected from all these creditors, these small amounts by the insolvency professionals. So I think we
So,
conclude our
yes,
session
yes.
today, and we will start from these definitions. And as I said, that this is a detailed discussion. It is not a panel discussion. It's a detailed clause by clause discussion. It is most important for the professionals. It is most important for the bankers, creditors, and also for the debtors to understand.
So thank you for the over 300 participants who have come, who have heard us today, and thank you for raising so many questions, which will bring clarity to all the concepts within this subject. Looking forward to see all of you next week, same time, 11 o'clock on Sunday.
Thank you very much, participants, and I look forward to your participation again next Sunday, 11 a.m. And at last, I would always say that this is there is no other intention. This is my way of learning, and we will continue this process of learning and spreading the message to everyone that this is rather better for us, and it is better for everyone, spreading the knowledge and experience. Thank you all the participants.
Thank you.